everyone. Welcome back to The Presumption. I'm Sara Azari, joined by my co-host, Jim Griffin. Hi, Jim.
Hey, Sara.
And Matt, our producer. And
morning.
Today, we really have a special guest, Natalie Ram, professor of law, with us. Welcome, Natalie.
Hello. Thanks for having me.
And, you know, we've on this podcast, an issue that's been really interesting for Jim and I, because we have not had it come up yet in our own cases, has been the issue of IgG, also known as FGG. Am I correct, Natalie, that they're interchangeable: forensic genetic genealogy and investigative genetic genealogy?
Yeah, it has many names. We've had IgG, FGG, FGGS, FIGG. Depending on who you ask, you'll get a different acronym.
Right. So last night, Jim was texting me saying, well, wait, FGG, because we've been referring it to as IgG. And on this podcast, we say whatever we want. And I was like, well, effing genetic genealogy. I was like, it's the same as IgG. But anyway, just an intro for those of you who don't know Natalie and haven't read her wonderful work. She is a professor of law at the University of Maryland Francis King Carey School of Law and adjunct faculty at the Berman Institute of Bioethics at Johns Hopkins University. Professor Ram is a leading scholar on the intersection of genetic privacy and the criminal legal system. Her work has been published in both law reviews and scientific journals, including Harvard Law Review, Virginia Law Review, Texas Law Review, Science, and Nature Biotechnology. She was a 2021 Greenwald Faculty Scholar in Bioethics and is an elected member of the American Law Institute. Before joining Maryland Carey Law, Professor Ram clerked for Judge Guido Calabresi, U.S. Supreme Court of Appeals for the Second Circuit, and for Associate Justice Stephen Breyer, one of our favorites, U.S. Supreme Court. She earned her JD at Yale Law School and her undergraduate degree in public and international affairs at Princeton University. So, Natalie, among your very brilliant arguments in all these articles that you've written, only some of which that I've gotten to so far before this interview, there are a few that were really significant for us. For one, like I said, neither of us have had this issue come up. We've had a lot of DNA, obviously, but play a role in our own cases. So it's good. It's a good learning curve for us. But there are cases that we follow in the news and that our audience is really fascinated by, like Gilgo, Koberger. And of course, we haven't talked about the Golden State Killer, but that was sort of one of the bigger cases that shed light on this IgG. So we have a lot of questions, but we're going to give you the mic, and I'm going to let Jim start with the first topic or question.
Yeah, sure. Hey, Natalie, nice to meet you.
Nice to meet you.
Yeah, Sara mentioned the Golden State Killer case. That was a serial murderer and rapist in California who eluded capture in the 70s and 80s. And apparently, as science developed, genetics developed, they were able to find some DNA sample that had never been used in a freezer. And then they just, created a profile, right? And logged onto some open source genealogy database. And they were able to locate a distant relative. Is that right?
So it's not quite that simple. So you're right that the genetic
this way then.
genetic forensic science has advanced a lot over the last 40 years, 30 to 40 years. So when DNA forensics was first getting its start in the early 90s, that's when we had states just beginning to start to collect DNA from individuals who were convicted of certain exceptionally heinous offenses. It was mostly sexual offenses. Those were the cases where you would have the best DNA samples from the crime scene, from a rape kit. And those were the cases that were best able to be solved using genetic data. And so states started to pass laws to say we're going to keep certain people's DNA on file if they've committed a particular kind of offense, what's called a qualifying offense. Mm-hmm. That all got formalized in the mid-90s into what's called CODIS, the Combined DNA
Right.
Image. And I'm sure you're familiar with that. What happens with IgG is really quite different than what happens with CODIS, right? So we're looking at, law enforcement, when they're doing IGG, is looking at a different database, right? It's not looking anymore at people who have committed a qualifying offense, people who have had some past interaction with the criminal legal system, been convicted or now arrested for a particular kind of crime. These are people who, have used a 23andMe kit and then uploaded their data to another platform, or, did their DNA, their recreational DNA testing, not through 23andMe, but say through a service like Family Tree DNA or MyHeritage, which both accepts third-party data uploads and also will do the analysis for you. So it's a totally different database, composed of a different kind of population, right? It's not a population of people who have had a criminal history. It's people who, are just ordinary members of the public, some of whom undoubtedly have a criminal history, but that's not why they're in that database, right? They're in that database because they've done one of these tests. Or, as actually is often the case with IGG, the person who's arrested doesn't have their own cellular data in the database. Instead, it's some distant cousin of theirs, right? But that our DNA and between our genetic relatives is still similar enough that you can identify me, even though I've never used one of these tests, through, say, my third cousin, right? And part of that, the reason why you can identify someone through such a distant genetic relative, is that the data that's being examined is a very different kind of data. So if we're talking about CODIS profiles, we're talking about non-coding DNA in what's called STRs. These are kind of like little stutters in the DNA, right? And the FBI says they've really purposefully and intentionally selected DNA markers that are in non-coding DNA. They don't have any medical relevance as far as we know, right? The more we learn about DNA, the more we realize maybe that's only a matter of time, right? The DNA being used in these consumer genetics platforms, your 23andMe's, your Family Tree DNAs, and the like, are hundreds of thousands of DNA data points across all different parts of DNA, coding and non-coding alike, right? And so it's just so much more information rich, in some instances revealing really sensitive, medically relevant data, as well as a sprawling family tree, right? So I think that's one really important thing to understand when we're thinking about what's really new about IGG. It's using a different type of database for investigative law enforcement purposes, and the kind of data that's in those databases is really different, and the population in that database.
Go ahead.
Just so I understand, I mean, if I do a buccal swab on me and submit it to the 23andMe, it's the same buccal swab that law enforcement would do on an inmate or by court order. But what you're saying is, when it goes to the lab, the criminal forensic lab is only looking at the STR, which is, they say that's the junk DNA in the DNA chain. And then if it goes to a genetic lab, it's a much broader analysis of the DNA. Is that correct?
That's right. Yeah, that's right. Though we should, in the interest of full being precise, in the interest of being really precise, we should note 23andMe makes you give a really big spit swab, not a buccal swab. But it's still a DNA sample by mouth.
Is that because on the genetic side, they create what they call a SNP instead of the SDR?
That's right. So STRs are what we have when we're talking about CODIS profiles.
Right.
SNPs, that's SNP. That stands for single nucleotide polymorphism. It's one base pair in that 3 billion base pair chain that is the human genome, right? One single base that differs from one person to another. Now, let's be really clear. All human beings are more than 99.9% genetically identical, but that still leaves millions of SNPs where we vary. And that is responsible for the amazing genetic variability we see in the human population, right? Both our medical risks or medical features, also our differences in appearance that are due to genetic differences, right? And so we're all extremely genetically similar, but where we're different, we're still different enough that the DNA can be an amazingly powerful identifier when it's done properly.
So Natalie, do you know if there are, certified law enforcement forensic labs, any like South Carolina, we have a lab at SLED and they do their own DNA testing, and I'm sure every state has similars, and we have them at the local level as well. But are there state labs that do the SNPs as well, or does all that have to be outsourced to these private companies?
So today, nearly all of it is outsourced. There are some labs that are beginning to bring that in-house. I know the Florida Department of Law Enforcement, the FDLE, which has historically been kind of at the leading edge of genetic forensics, I think is now doing some of that in lab or in-house. But I'm not 100% certain about that. I wouldn't be surprised to see more of that come in-house in the near future, but up until now, the vast majority of it is being farmed out or contracted out to outside labs and outside genealogists for the most part.
Well, and that's giving DAs and prosecutors the ability to shield discoverability, and because they argue that we didn't do the testing, and we sent it out, and it's like, well, just because you farm it out doesn't mean that it's not discoverable. But you argue, Natalie, that there's a disjunction between genetic relatedness and voluntariness, and the challenges that this disjunction poses for law enforcement use of consumer genetic platforms. Tell us what you mean by genetic relatedness, voluntariness, and this problematic disjunction.
Yeah. So as I said, in the vast majority, nearly all of the cases in which IgG has led to an arrest thus far, the person who's ultimately arrested and charged with a crime isn't actually the person who put their DNA profile into one of these consumer genetics platforms. It's some genetic relative of theirs, right? Mm-hmm. The number one argument that we hear from law enforcement and from practitioners of IgG, the genetic genealogists themselves, for why it's totally fine in their view for law enforcement to use IgG, to use these consumer genetics platforms for their investigative purposes, is that the DNA on those platforms has been volunteered, right? That nobody's been forced to put their DNA into those platforms. And because it's volunteered, therefore there's no Fourth Amendment claim there. Now,
it's consensual, like what
that's right.
Using consent as the Fourth Amendment lingo.
So that's the theory, right? I've argued in some work that, in fact, that argument is questionable, even with respect to the people who are using those platforms, if they're not aware of and consenting to law enforcement use specifically, right? So 23andMe says law enforcement is not welcome, and we have practical barriers that keep law enforcement out. We don't take those third-party data uploads. And people therefore reasonably believe and expect that their data on 23andMe will not be available for law enforcement purposes, right? And I think
I didn't know this. I thought that all of these platforms have an option where you can opt in or out. Oh, okay.
No. So the two largest players in the field, and I should be clear, this is a matter that has been in flux over time, and what we say today is not guaranteed to be true tomorrow, because terms of service can be changed by online service providers at any time, with or without explicit notice to users, right? So there's a major problem dealing with consent to contractual changes to the terms of service in just about anything online. It's true for Facebook, Meta. It's true for anything where you're like clicking I accept without reading that terms of service. There's almost certain to be a provision in there that says, by the way, we can change this at any time. And like, if you keep using our service, you are assumed to have consented to whatever changes we make. So I just want to flag that. Since 2018, since the arrest of the Golden State Killer case, the arrest in the Golden State Killer case, right, which sort of kickstarted this whole IgG field, 23andMe and Ancestry.com have both said law enforcement is not welcome. We don't want them here. and we promise we're going to fight law enforcement if they try to get in, right? So that's been true for the last 5.5 years. Again, I can't predict the future, but those two services appear to see it in their own financial and economic interest to exclude law enforcement, right?
So which
Then
ones
there
are the ones
are
that give you the option?
So there are two major platforms that cooperate openly with law enforcement. That's GEDmatch and Family Tree DNA. Both of those now have an option that says, do you want to be part of what they call family match, the familial matching service, right? GEDmatch had some early bumps in the road where they opted everyone into law enforcement use. Then they opted everyone who had an existing profile out of law enforcement use. Then they created a matching option, which now you have to select into or out of when you join the service, at least with respect to investigations where law enforcement is looking for a perpetrator. If what law enforcement is trying to do is identify an unidentified human remains case, then in fact, you can't opt out of that on GEDmatch, right? Though, of course, if you identify unidentified human remains, often that will give you some clue about who the perpetrator might be. So I don't think the division between unidentified human remains cases and perpetrator cases is as clean as GEDmatch would like to present it as being.
So what is I'm not clear on what the protocol is for FBI, for example. I know that they're only allowed to access certain databases for this type of family tree investigation. What are those databases, if you know, that the FBI can use?
So the FBI has an interim policy from 2019 that says that anyone in federal law enforcement or anyone who has a grant from the federal government specifically earmarked for IGG work can only use those funds or only conduct investigations in platforms that give explicit notice to platform users that law enforcement may be using the platform. So that would be GEDmatch and Family Tree DNA. Family Tree DNA being the other major service that has that sort of family matching service and open cooperation with law enforcement. That said, law enforcement, unclear whether that includes federal law enforcement, but at least some law enforcement entities have also made use of a platform called MyHeritage. The terms of service at MyHeritage say, if you are law enforcement, you are not welcome here. Do not use our platform for law enforcement purposes. But because the platform will accept data developed elsewhere, law enforcement can just lie and say, oh yeah, this is totally my DNA that I got from 23andMe or wherever. And it's not at all a law enforcement related use. And then they can make matches in the MyHeritage database. So MyHeritage has a policy on the books that says no law enforcement, but more difficulty as a practical matter policing that. For what it's worth, this is also true at Family Tree DNA and at GEDmatch, both of which say if you're law enforcement, you have to go through our law enforcement protocol. So you only make matches with people who have opted in or failed to opt out of law enforcement matching. But of course, if law enforcement decides they're happy enough to lie about the source of the DNA and say it's not law enforcement DNA, then they're able to upload the data just like anybody else and make matches in the full database.
So that's the disjunction that you're talking about.
Well, so that's part of the disjunction. And I'm sorry to be a little long.
No, this is great.
To bring this back to the disjunction that I've been talking about in my writing, right? Again, most of the people who are being arrested aren't people who have actually done the DNA testing and put their data on one of these platforms. Instead, they're genetic relatives of those individuals. And here's the disjunction. We don't choose our genetic relatives. There's literally nothing voluntary about our genetic relationships with our family members, with perhaps one exception, right? If I choose to have a child, I am in some sense consenting to put my genetic information in the hands of another human being, and they can use our shared DNA to identify me. So maybe it's true that children can rat out their parents, right? But Lord knows, we don't choose our genetic parents. My kids didn't choose me. We don't choose our siblings, how many of them we have. We don't choose our aunts, uncles, or cousins. And yet each and every one of those individuals has DNA that can be used to learn about or identify us. And so if the argument for why law enforcement can use these consumer genetics platforms is based on voluntariness, that voluntariness argument ends the minute we start looking beyond the actual individuals who have uploaded their DNA to the platform, and we start looking at their genetic relatives who are implicitly identifiable through our commonly shared DNA by virtue of our relatedness. So that's the disjunction that I'm talking about.
Yeah, pretty messed up. Okay, Jim, to you on the ethical stuff.
Yeah, the legal and ethical dilemmas involved in this whole database. I think you're probably touching on those now, right? But so let me ask you sort of a devil's advocate. So, I put my sample in the DNA database, and I agree for law enforcement to use it. What's the difference between that and my agreement to go down to the police department and tell law enforcement every relative that I know about? I mean, isn't that the argument against what you're saying?
So I think those are similar in some ways, but really importantly different in others, right? How many genetic relatives are you sure you know about and that you could identify for law enforcement?
Right.
You might know maybe you know your first cousins. Maybe you know some second cousins. You might even know some third cousins, but you got hundreds of third cousins and beyond, fourth cousins, fifth cousins, right? Thousands of people that you may not be aware of, right? So number one, the sprawling tree that is identifiable through DNA is much more sprawling than our social relationships. Mm. The other part of it is that our social relationships may in some sense be thrust upon us, but they're also voluntarily undertaken and maintained. So if I decide, let's say we're cousins, Jim, and I decide I don't really want you knowing about me because I don't trust you, I can estrange myself from you. I can cut off that social relationship. I can unfriend you on Facebook or whatever social media platform we might have had a connection with.
I did that to my sister once, and it took her 2 years before she talked to me again. So apparently that was a mistake. I'm sorry, sis.
So I can cut off that social relationship, but there is no way that you can cut off a genetic relationship. It is immutable. You can't change your DNA. You can't change those biological ties between genetic relatives. And so I think that those relationships are really importantly different, both because they're more sprawling, the genetic relationships, to include people that you may not even know exist. In fact, that's often the case, right? And there's no way out of them. Mm-hmm. If you could sever those genetic ties, right? Then we might say, well, you failed to sever your genetic ties, so therefore you, in some sense, consented to them.
Right.
Now, that's a very thin notion of voluntariness, but the law sometimes uses very kind of thin and weak notions of voluntariness. But we don't even have that here. There's literally no way to sever that genetic relatedness tie. That is a relationship you didn't choose, and you can't change, and you can't practically manage because the family tree that can be used to identify you is so sprawling. It includes thousands of individuals, many of whom you don't even know exist.
Mm-hmm.
Right.
So on this whole issue of consent and involuntariness that you're talking about, I mean, this is when I was really taking a deep dive into Kohberger, it just reeked of Fourth Amendment concerns. And yet the DA was saying, the state prosecutor was saying, well, we're not bringing in the IGG. The IGG was an informant. Or Jim and I were laughing at that. But anyway, the IGG was an informant. We're not bringing that in as evidence at trial. So, there's really nothing to exclude. It's not material. You don't get to have it. So in some ways, I guess this idea that a relative consented is supposedly curing this issue. We know it's not. But you cite to two cases to support, your constitutional concerns. One is Carpenter versus U.S., a Supreme Court decision, which stands for the third-party doctrine and privacy rights, and then a Maryland Supreme Court case, State versus Andrews, that actually has to do with stingray devices and Fourth Amendment harm related to that. Can you elaborate for us on, the real Fourth Amendment constitutional concerns around this, besides what you've just said?
Yeah, so I think if it is established, right, and it's by no means certain that it would be established, but I've argued in my scholarship that there is a Fourth Amendment wrong that is committed when IgG is undertaken, at the very least when it's used to identify genetic relatives of people who have put their DNA in the database, if not, in some instances, even people who have themselves put their DNA on a database that excludes law enforcement, right? So if that is a Fourth Amendment injury, right, that's a constitutional violation, then the question becomes whether any other evidence that would be introduced in court is the fruit of that poisonous tree, right? So there are some exceptions to the fruit of the poisonous tree doctrine, but in basic terms, in case your audience isn't super familiar with that doctrine, it's the idea that if there is a constitutional violation, not only is the evidence or information obtained through the unconstitutional search excludable from evidence, but so too is anything that flows but for in a fashion from that unconstitutional search, right? With a few exceptions. So if IgG violates the Fourth Amendment, then further on downstream, DNA that was compelled or collected from the suspect, the defendant, might be tainted as the fruit of that poisonous tree. Now, law enforcement will argue that, say, there's an independent source, right? There's some other path that they could have followed to come to suspect the defendant in an individual case. And so because there's that independent path untainted by the constitutional violation, that therefore whatever they're going to introduce in court ultimately is, safe. It's not going to be tainted as fruit of the poisonous search, right? Now, law enforcement in, say, the Kohberger case very strategically left out any mention of IgG in all of their affidavits, perhaps in an effort to keep anybody from knowing that IgG was being used, because it's still a quite controversial new practice, and in part perhaps to try to support their assertion later that there's a different path, an independent source that they could use to get to Kohberger.
Well, Natalie, to your point on that, and this is what I've always been arguing about this, is that they came up with the car that he's not seen driving the car. He's the registered owner of a car that looks like the car that's seen on surveillance footage. But initially the car was one make and model. Then it changed to a different make and model that matched him as a registered owner. And to this day, we don't know whether this informant that's the IgG, whether that came in first and then the car got corrected, or whether the car came in, and it matters, right? So this idea, yeah.
Yeah, you might really wonder if they initially used IgG to identify the suspect and then worked backwards from there to kind of ex post create an alternate evidentiary path, right? In order to try to sever a search, if IgG is a search, an unconstitutional search, as I've argued that it is, right? From the evidence that they want to introduce in court. Right. So that's one piece of it. Now, the Carpenter case goes to whether or not IgG itself is an unconstitutional search. The Carpenter case is about cell phone location data, which might seem really different from DNA, but I actually think has some strong similarities, particularly given the analysis that the court gives in the Carpenter case. So that case is from 2018. It was decided about 6 weeks after the Golden State Killer was arrested. So these two practices, both the kind of Carpenter revolution in Fourth Amendment law, such as it is, and IgG itself, kind of are born in the same spring. And in Carpenter, the court says, since the 70s, we've said that if you share your data with some third party service provider, then well, that data couldn't have been very private. You couldn't have expected that it would be private. And therefore, you don't have a Fourth Amendment expectation of privacy. It's not a Fourth Amendment search for law enforcement to access that. And by the way, when you shared it, you assumed the risk that whoever you shared it with was going to sell you out to the cops, and therefore, ditto, no Fourth Amendment search at all. The Fourth Amendment just doesn't care about that. Now, the cases in the 1970s that kind of created what we call the third party doctrine were about a pen register, what telephone numbers you dial at a time when the telephone company was much more involved in connecting phones, right? Or keeping those records, and your bank records, your checkbook, your checkbook records, right? And then, of course, in the last 20 years, especially, we get, and 30 years since the dawn of the internet, we enter what Justice Kennedy, now no longer on the bench, but what he once called the cyber age, right? The internet age, where everything we do goes through some sort of third party intermediary. Our emails our correspondence doesn't go through the US Postal Service. It goes through Google, if you use Gmail or some other third party service provider. Our text messages are now written. They're not phone conversations, right? So everything we're doing is moving through some kind of third party intermediary, right? When I would go to the library and do research, that is now stuff I'm looking up on Google, right? And so Google or Alphabet has all that data about me, right? And so the question became in Carpenter, can we really adhere to this idea that so long as your data is moving through some third-party intermediary, you voluntarily assume the risk that whoever has that data is going to sell you out to the cops? Is it really true that you have no Fourth Amendment interest in that data? And Carpenter comes along and says, yeah, we're not really comfortable with that in the modern age. And it does so in the context of cell phone usage, right? So what it says is that having a cell phone and using it and keeping it on, even if you know that it's connecting and pinging off of cell towers every couple of seconds or every couple of minutes, right? That's not you voluntarily undertaking the risk that your cell phone company is going to share all that data with law enforcement. You do have an expectation of privacy in your physical movements as revealed by your cell phone location data. The court implies, doesn't hold, but implies strongly that your email contents, despite moving through your service provider, are also protected by the Fourth Amendment. And so then the question, of course, is what else is like cell phone location data? Well, the court gives us some some guideposts for that analysis, right? They want to know how sensitive is the data that's being accessed, that law enforcement would access. They want to know against what portion of the population would that data be accessible, right? How many people can law enforcement kind of follow around by using a particular data source? They want to know how quick and easy is it to run that search, right? Can you do it with just the click of a button, right? Those sorts of features. And they want to know about voluntariness. How voluntary is your use of a particular service? So think about, let's say, our genetic relatives. I didn't upload my DNA to Family Tree DNA, but my third cousin did. Well, if you're looking in that database for everyone that's in that database and everyone out to their third or fourth cousin, that includes, by one statistical estimate, once you have 2 million people in the database, more than 60% of Americans of European descent. If you can access, say, 4 or 5 million profiles, you can cover more than 90% of Americans of European descent. That's everybody. That's basically everybody, right?
I just want to jump in and ask a question, which is, has any of this DNA evidence is it like irrefutable, or is there a margin of error? Like, we are all saying this is the Golden State Killer, but based on what you were saying earlier, couldn't it actually have been his fourth cousin who shares 99% of the same genetic profile?
So it's almost certain not to be his fourth cousin, because there will be genetic differences between him and his fourth cousin that indicate that it's definitely not the fourth cousin, but it might be, say, the Golden State Killer or his brother, right? Or some number of fourth cousins around the family tree, right? Now, if you ask the genealogist, they'll tell you we're never wrong. And if we are, by the way, the law enforcement's going to go pick up that suspect's trash and make a 1-to-1 match before they arrest someone. But of course, they'll never go pick up that person's trash if they don't already suspect them.
Right.
By the way, even if the trash shows that it's not that guy, that in fact the IGG led them to the wrong person, which, by the way, it did initially in the Golden State Killer case. They went and collected DNA from another man before they got around to the actual Golden State Killer, right? That DNA from that trash, that DNA profile is probably going to live forever on a local DNA database held by the law enforcement entity, right? Mm-hmm. I do want to get back to Carpenter, though, because I do think it's important, right? Yeah. So when we're thinking about these consumer genetics platforms, as I said earlier, the kind of DNA that we're talking about can include and can disclose really sensitive medical data. Mm-hmm. Law enforcement and genetic genealogists will tell you they're not looking at the individual level SNPs, so they can't really tell the medically relevant data. That is true and not so true. There are folks in the field who say you can work backwards from shared segments to infer medically relevant information. So potentially highly sensitive information. And DNA is, of course, highly sensitive. Mm-hmm. This is a search that's going to effectively run against everyone in the U.S. population.
Mm-hmm. So Natalie, for example, you
can run that search against everyone in the database. And as I said, we don't voluntarily share our genetic data with our genetic relatives. So if you're thinking about that Carpenter standard, it's as true for genetic data and genetic relative data, even more so than it is for your cell phone location data.
But let me ask you this: with Carpenter, if you're talking about cell phone data, are you? I mean, if I'm suspected of committing a crime and I've sent illicit text messages to Jim, they can get a search warrant.
They could.
And they can, look at, it depends if it's an iMessage or an SMS or whatever it is, but they can certainly access my emails, subpoena Google and all that stuff. So really what we're talking about here is the involuntary, right? In other words, the involuntary accessing as opposed to via a subpoena.
Well, a subpoena or a warrant, right?
Or warrant, I'm sorry.
A warrant, Amendment question, then right. A warrant.
Yeah, in Carpenter, Justice Roberts says a subpoena is not good enough. I mean, you got to have a search warrant. They're
warrant. Not. Yeah, I meant a warrant. Sorry, yeah.
And Sara, in Carpenter, and it was cell phone location data, and there was a federal statute that says you could get it from a carrier if you had some level of proof and you made an application, and they did that. And what was challenged was, well, that's not a search warrant. You've got to have a search warrant. And the significance was, as I understand it, Natalie, is that it was equivalent to GPS data. And so what we're talking about in Carpenter is where your phone pings off a tower. And so the state was saying, well, that just gives you a cone, an area of distance, and it's not that accurate. And they held the stuff for 5 years. And so you can go 5 years of time. And I really liked some of the language in Carpenter that talked about, well, not only we have to predict, address what's happening now, but we have to sort of predict what's going to happen 10 years from now. That's and right. The cones are getting smaller because there are more towers going up. And it's,
that's right.
So Natalie, look, there's nothing like having a law professor educating everybody, but Jim is my walking Westlaw.
Yeah, well,
literally. I can ask him anything and he'll, cite the dissent and the,
Anyway. This is a really interesting case. I recommend it as great reading for anyone interested in the modern Fourth Amendment.
Yeah, no, because it's really becoming smaller and smaller, right? Almost.
And Natalie, before you came on, I did research to try to find some, where Carpenter's been applied to this genealogy, and I couldn't find any cases. Are you aware of any?
So there are some. Mostly what has happened is that courts have said, well, it wasn't your DNA that was uploaded to the platform. It was your cousin's DNA. And therefore, you don't have standing to challenge the search, right? Because you didn't upload your own DNA. Now, of course, that's kind of the point of my whole argument about the disjunction between voluntariness and genetic relatedness, right? It was my cousin was the one who uploaded their DNA, but you used it to learn about and identify me. And our relationship to each other, it was a product of involuntary biology, right? Carpenter has an answer to this too, by the way. Carpenter says that Mr. Carpenter, the criminal defendant in that case, had an expectation of privacy in his cell phone location data, even though the cell phone location records were held by the cell phone company as their property, as their business record. And so what it means is that even if information is held or even owned by another person, if it is sensitive and informative about me, then I might have an expectation of privacy in it. Now, I will concede it is a little weird to think about me having an expectation of privacy in my cousin's DNA, but that is, that's an inevitable product, I think, of like the language that we use in the Fourth Amendment space and the ways in which DNA relationships between genetic relatives are just really, really hard for the law to describe. We are not used to having relationships that are totally involuntarily thrust upon us. We're used to relationships where if my information is shared with someone, there's at least some measure of voluntariness. It might be that really thin notion of voluntariness, that very weak notion of voluntariness. Like, I have a cell phone, I carry it around, but of course it rejects that in Carpenter. And here it's even less than that, right? Now, I did want to come back to the Andrews point, because I think that connects up to what you said earlier about the Koberger case, right? Which is that in State versus Andrews, that's a Maryland state Supreme Court decision, I believe, in which the court holds that it is a Fourth Amendment violation for law enforcement to have intentionally and persistently failed to disclose their use of an advanced technological tool for criminal investigations, like a Stingray device. Right. A Stingray device is designed to kind of gather up all the kind of identifiers of any cell phone in the area of the Stingray device. So it helps you track where someone is if you know the kind of identifier of their particular cell phone unit, right? Their particular phone. And in that case, the FBI had basically required all local law enforcement to basically not disclose in their affidavits, search warrant or otherwise, pen register, etc., that they were using a Stingray device. Law enforcement had, in fact, in that case, applied for a pen register and kind of hidden the fact that under the pen register authorization, they were going to use a Stingray device, which is not a pen register. And the court there said, no. When you undertake such efforts to shield a piece of technology from the court's own knowledge, that deprives both the court of its opportunity to assess the constitutionality of that technology and the defense of its right to mount a defense. And I think in that way, it can be quite similar to what we've seen in the IGG space, right? Where law enforcement has been quite careful in many cases, not all of them, but many cases, to just leave out any mention of IGG. Law enforcement has offered a number of justifications for leaving it out of the affidavits. As I said, I think in part it's in order to create this alternate evidentiary path so that they can argue that even if there is a Fourth Amendment violation in the IGG, that there's a severing of the independent source, not fruit of the poisonous tree, right? Or law enforcement has said, we really don't want people to know that we're doing IGG, because if people know we're doing IGG, maybe they'll be creeped out and they won't put as much DNA on these consumer genetics platforms. To which I say, if your whole pitch is that people are voluntarily sharing DNA with law enforcement, then hiding that because
Right.
you fear that people won't consent is kind of,
Shady.
yeah, or it's telling me you don't actually believe people are
Right.
thoroughly sharing with law enforcement,
Mm-hmm.
right?
Mm-hmm.
And
So
that, that seems to me is what happened or happening in the Koberger case. I mean, in the search warrant affidavit, they don't really play up the IgG, and they say, "Oh, we did a search of the trash, and we got DNA from the trash, and that's how that's our source." And
yeah. So what's interesting is that at least in some of the earlier cases using IgG, say in 2018, 2019, when this was just starting to ramp up, you would have a press conference. There would be a press conference, right, in which the DA or the arresting officer would come out and explain, "Oh, we found this guy through IgG." They wouldn't call it IgG. They would describe it using some other phrase or whatever. But they would say, "The guy we arrested was never on our radar. We never would have suspected him but for the IgG." And I think that's telling.
Yeah.
I think that's really telling that the IgG is really the thing that's driving these investigations.
Well, in Koberger, I'm only familiar with a handful of trial court rulings, and one being in California, Northern California, where repeatedly the trial court denies a defense motion for discovery for IgG materials. And in Koberger, at least the judge, my understanding is, has conducted an in-camera and has ruled that some of them, we don't know what, but at least some of these materials have been deemed to be relevant to Koberger's defense and are going to be disclosed under seal to the defense. But you mentioned that that in this sort of context of lack of transparency on this issue, that there's rumors that the Gilgo Beach, the Rex Heuermann case also was cracked through use of IgG. And to me, that case has such strong DNA evidence. It's like, do you really need IgG? I mean, do you know how IgG plays out in that case?
No, I don't. And as you said, the best I can say about that is that I've heard some background rumors from some people in the IgG practitioner community suggesting that there may have been IgG in that case as well. Mm-hmm. Now, that's literally all as much as I know, and there's been no confirmation of that. Yeah. If it turns out that is the case, that there was a IgG used in that case too, look, that what that indicates is that there are substantial efforts by law enforcement not to disclose the use of IgG. I mean, law enforcement seems really proud of this new method that they have.
They can keep
I'm
secret.
not sure why they're going to such great lengths to keep it secret.
Yeah.
Especially since, the reasons that law enforcement often refuses to disclose a law enforcement investigative method is in part because of fears that that criminal defendants will find a way to circumvent that method.
Right.
But I mean, here, it's being used largely in cold cases where the DNA is available or not already. And going forward, if we're thinking about criminal defendants trying to avoid identification, they're trying to avoid depositing DNA of any kind at any crime scene.
No.
And so I'm not sure that IgG is really changing that, circumvention calculus insofar that as criminal defendants might actually be thinking about that.
And, it seems to me you have these private labs that, probably don't have to adhere to the same standards as a certified, criminal laboratory run by the state, and the risk of cross-contamination or who knows what. And, that's a real issue, I suspect.
Yeah. So I'm glad that you raised that point. And that connects back to Matt's question earlier about whether there are error rates that are being reported for this. As I mentioned, if you ask the genetic genealogist, they'll say, we're never wrong. But of course, no forensic method has a 0% error rate. And there are instances in which, say, the genetic genealogy will identify a small number of suspects, all of which will then be kind of followed around and have their trash collected to make that kind of one-to-one comparison. But cases are coming, and soon, if not already underway, in which the DNA that was recovered from the crime scene is degraded enough or of small enough quantity that you can only test it one time. Only pull one crime scene profile off of it. And so they're not going to pull an STR profile. They're only going to pull the SNP profile. And if that outside lab doesn't do it right, you might get a really, really solid, good match that is to the wrong person. It looks, it's a great DNA match, but it turns out the DNA analysis was done poorly, and therefore you're putting the wrong person.
We're definitely interested in those cases when they come out. Do share them with us. This is such a fascinating issue. But, I want to close with IGG or FGG in wrongful conviction cases, because, we know from the work that Barry Scheck is doing with the Innocence Project, and then also in talking to CeCe Moore, who's done some of that work with folks like Barry, that there's also that benefit of, exonerating someone who's been wrongfully convicted, but it's not that easy. Please explain.
So when we're talking about exonerations, I think it's worth noting here that not kind of the policy landscape here, which is a really interesting and developing one. And so you and I have talked, or we've talked about the FBI interim policy. In addition, there are at least 3 states that have laws on the books now that regulate IGG. So Maryland has a comprehensive regulatory scheme. I was really honored to play a role in being a part of a working group that led to that legislation. Utah watered down Maryland's law and passed a weaker version, but still has some legislation in place. And then Montana has a very, very short law that basically says you need a warrant for this or consent, right? Both the Maryland and the Utah laws have provisions providing for exoneration use, post-conviction use. The platforms often say you can do law enforcement related stuff if you are law enforcement, which, by the way, then requires post-conviction counsel to get the cooperation of the district attorney's office, the prosecutor's office, in order to move forward with post-conviction IGG testing. Number one, under the Maryland and Utah laws, at least under the Maryland law, that kind of cooperation is not, you don't have to seek the voluntary cooperation of the prosecutor if you're post-conviction counsel. If you qualify, a court can order that be undertaken. So Maryland is really at the forefront here. I'm really proud of the work we've done in Maryland on regulating IGG, making it available for its best and most justifiable use cases, but also, significantly regulating it to make sure that law enforcement is playing by reasonable rules. Right?
But in jurisdictions that are not like Maryland and Utah, in jurisdictions where you're at the mercy of a prosecutor who doesn't really want your guy out.
That's right. So that's one major problem, right? That it can be really difficult. And this is true for DNA evidence in post-conviction settings all over the country, right? But since IGG is new, you may have even more difficulty obtaining the cooperation of the local prosecutor. And the other part of it is just generally, the fact that IGG has been used for exoneration. What does that mean? What does it mean to use IGG for exoneration? Well, what that means is that the Innocence Project and the genetic genealogists working with them not only demonstrated that there was a mismatch between the crime scene DNA profile and the person that was actually convicted of the crime, who is actually innocent. Those two profiles definitely don't match. That appears not to have been enough to secure the release of that wrongly convicted person. Instead, that wrongly convicted person and their post-conviction counsel, their innocence counsel, had to do more. They had to undertake IGG in order to find the actual perpetrator of the crime.
My Lord.
So what that means effectively is that, this isn't unique to the IGG space. But I think what we're seeing in the exoneration argument related to IGG, that IGG is great because it can be used for exonerations too. I mean, yeah, it can, but the fact that it's needed is simply a reflection of the extraordinary burden that we put on wrongly convicted individuals, not merely to prove that they didn't do it, but to identify the person who actually did it, to do the prosecutor and the investigating, law enforcement officer's job for them, but better.
Jim,
that's
maybe
extraordinary burden.
Jim, you got to keep Natalie's number on hand, because maybe we can get some IGG going in the Murdaugh case. We can get his wrongful conviction overturned. He's getting all sorts of injustices thrown his way. So, Natalie, it has been an absolute pleasure to have you on. I learned so much in this hour, and I know that someday soon we're going to be needing to consult with you on our cases. So we will stay in touch, and I'd love to get the cases too that you're talking about coming down the pipeline on this issue.
Yeah, it's been 5 years, but it is still the early days of the IGG field.
How long have you been doing this? Well, you told me it was like 15 years.
Yeah. So I've been writing about familial genetic relatedness and criminal investigation since 2008, which is when, in the waning days of the Bush administration, the Bush administration outgoing kind of put in place a new rule that left open the possibility of doing familial identification in CODIS. That ended up not happening. The FBI doesn't do familial identification in CODIS, but many states do. And that's what that rulemaking was related to. And I said, that doesn't seem right. If the reason why someone's DNA is in CODIS is because they committed a crime, that shouldn't allow you to identify their family member as a suspect. And I think, as I said, the same thing is true to kind of the nth degree when we're talking about IGG.
Yeah, it's really fascinating. And, it just dawned on me as you were talking that I remember in law school, there was some elective offered, this was a long time ago, on, the law and bioethics or something. And I was like, I'm not taking that. What's that good for? Like, I'm never going to use that. Like, what do I need to know about that? Yeah. And here we are in this era of, oh my God. I mean, it's
forensic technology has really taken on increasing significance over the last 30 years.
Yeah.
Whether it deserves to be called science, forensic science is
a different story.
It's a different story. I have a colleague who writes a lot about how we shouldn't call forensic science at all. And, look, DNA evidence can be exceptionally probative. It really can be a silver bullet if it's done properly, if it's done well, if it's done responsibly, if it's done lawfully. But
the moral of the story
is it's places for things to go wrong.
Yeah. Right. And I think, we've accepted it as this bulletproof. I mean, even, in our field, our knee-jerk reaction whenever we discover there's DNA in our case, we're like, oh, shit. But you go through the process, you consult, you try to figure out what potentially has gone wrong. And, to your point about the science, whether it's a science, the forensics, that's another way that prosecutors are dealing with IGG is by divorcing the SNP extraction from the family tree investigation to be able to say that the SNP part may be kind of science, but the family tree is just an investigative tool. So therefore it's not science. And that's a way that they're getting around producing the discovery on this is that it's not science. So we don't have to, it doesn't fall under our discovery statute or whatnot. Anyway, it's been wonderful having you.
It's been a pleasure.
And I hope that you stay in touch. And I think we can have many more conversations on this as things develop.
Thank you so much, Natalie.
Thank you.
And just before we sign off, I want to remind everybody to please subscribe to our podcast. It's called The Presumption. We're on all the podcast platforms, and you can watch us on YouTube, youtube.com/@thepresumption. Again, Natalie, thank you very much. I do feel like we are a hair away from Minority Report. We're even just thinking about doing a crime. You will go to prison for it. It is fucking terrifying. But yes, great episode to everybody. And until next time, Jim, Sarah,
We rest.
Rest.